Okay, we will get started. We are live now. Um, and I want to welcome all of our panelists today. Thank you very much for joining us. These are the tenX talks that the Orlando tech community does on a monthly basis. These are our monthly um, webinars that we do for an educational series for the startup community. Sheena, would you like to say a few words before?
Yes. I'm excited to join Innovate Orlando as the new CEO. I have a long standing relationship with Orlando, and it's truly exciting to take on this role. It's been fabulous to see the community grow and thrive over the last few years, where I stepped away to join a startup that expanded here to the Orlando region, Red 6, but now I'm back. So I am connecting with old friends, meeting new ones, and helping to understand how the Orlando tech community can continue to evolve to support all the entrepreneurs in the Orlando ecosystem, and how Innovate Orlando can provide support to our community to give more respect and light to all the extraordinary work that's being done here. I'm a true believer that Orlando has a deep history in engineering and technology and innovation. And the more that we can talk about it, the more that we can share stories like the ones you're going to hear today, the more that people will start to understand the work that's being done here and the power of this community. So please let me know if you want to connect. I'm always on LinkedIn or Sheena at innovateorlando.io. Happy to meet with you and connect with you. And I'm excited to listen to this panel today. Thanks,
All
Bob.
right. Okay. Thank you. Thank you very much. So each month we host these webinars and we hear from leaders in the community, and we really look at the hot topics that the startup community considers very, very important to them. We have a good ear to the ground to say we know these founders, we know what they're looking at, and what their big concerns are. So today we're going to talk about intellectual property, IP. We all talk about it, but most of us need to know a whole lot more. Um, and really, it's what's the real value of my IP, and how do I increase its value over time? How important is it to me? How do I think about my IP strategically, and how do I protect it and at an affordable cost? And then lastly, how do I monetize it? Now that I got this stuff, how do I monetize it? How do I really leverage it out there, not only for myself, my company, but also investors? So today we're very, very grateful to have actually two attorneys, Mark and Terry, and then also two founders. Um, they will give us their perspective on intellectual property, some of the things they've done with it, the highs and lows of it. So I want to welcome each of them. Thank you again for joining us today. I'm going to ask each of the panelists just to introduce themselves, quick intro, who you are, what you do. For the attorneys, please give us some examples of the type of clients that you work with, and for the founders, the type of problems that you're solving. We often do that with founders. First question we ask is what problem are you solving? So I'd like to hear that. So I'll start with Mark, if you could do a quick intro.
Thanks, Bob. Good morning, everyone. My name is Mark Ingram. We have a practice here in Central Florida called Corridor Legal, located in Orlando and Melbourne. And our focus is primarily in assisting founders, entrepreneurs, and investors who are interested in launching businesses and investing in businesses, primarily focused in emerging technologies. We work with a lot of startups. We work with a lot of entrepreneurs and investors who are interested in supporting startups. And so obviously intellectual property is primary focus for a lot of our clients. And a lot of the stuff we're going to talk about today, I'll primarily focus on sort of the corporate side of what you can do to protect IP, monetize IP, and grow your business around that.
Okay, thanks. Terry?
Good morning, everyone. I'm Terry Sanks, managing partner of UC Sanks, also in Orlando, Florida. And we just recently opened, as of today, we have an office in Jacksonville Beach, Florida. We're a full-service intellectual property law firm, and what we're known for is really from beneath the sea to outer space, we provide IP solutions to our clients. By that, I mean, we take a holistic approach. We're not looking at just one aspect of intellectual property. I mean, our clients may come with one saying, this is what we want. We will look at still giving them a holistic solution to their needs. Our clients range from startup companies. I have a lot of startups and founders I work with, universities, regional sized companies, as well as multinational conglomerates.
All right. Thanks, Terry. Derek?
Sure. Thanks for having me. I'm Derek Ricefield. I am co-founder and CFO of Edisource International. And the problem we're solving is helping B2B marketing companies and publishers use AI to create content in a secure and rigorous way. I have a background in media and technology. I was with McKinsey & Company for several years and then became an executive at Westinghouse and CBS, where I was the division president for new media, as it was then called. I'm a co-founder and the original chairman of MarketWatch. I helped develop Sportsline. Luminant Strands, which was an early AI company, which became a fraud detection company for banking institutions. MetaRail, a structured search company. BBN, a B2B digital ad network. Ondas Holdings, which has a major division, which is autonomous drones. And now Edisource.
Well, fantastic. Thanks, Derek. And Ali?
How's everyone? My name's Ali Mavan. I'm a serial entrepreneur. I've been building and selling companies for the last decade and a half. Relocated to Central Florida, to Orlando only 3 years ago, actually. And I'm currently CEO at TerraSynth, which is an artificial intelligence, data analysis, and visualization company that services primarily the Department of Defense. And then our commercial customers include like University of Central Florida. We focus on universities and research.
Okay. All right. Terrific. Thank you. Thank you. I think we've got a well-qualified panel. We talk about IP and in many, many different ways. So thanks again. I'll start off with what are some of the common mistakes startups makes when it comes to managing, protecting, and also monetizing the IP. What are the things that you see out there? I think I'll start with Terry. If you could say, hey, here are the common things that are happening out there right now.
One of the common things that's happening is waiting too long to secure your IP. It comes down from a startup's prioritizing what they need to do first. What's their budget like? They should start out early on trying to have at least an initial consult with an IP attorney. Explain what's going on, and at least then have a better concept from a planning purpose on what direction they're going to go. Because, for example, with a patent application or with a patent, if they've got a new invention, and if they're showing it, disclosing it to people, they've got 1 year to then file that provisional or non-provisional patent application. If they miss it, then they can't go back and grab it later. So it's just timing that they've got to be aware of. Same thing from a trademark perspective. If they start using a trademark and they're not using it yet, if they're saying this is what our product's going to be called and they're not using it in commerce yet, someone else could possibly swoop in, get that name first, and then they're going to have to come up with a new name.
Okay. All right. And Mark, what are you seeing common mistakes made by your clients?
Yeah, similar to Terry's advice, I think it's a matter of managing also internally and externally the way you're doing business with everyone. Something that we always encourage founders starting out is, starting with the founders themselves. We want to make sure that you've documented ownership of the IP in the right place. Oftentimes founders are inventors. Oftentimes they had a lot to do with the creation of that IP. And so as you're putting together your initial corporate governance and your agreements with service providers with the company, you want to make sure that the ownership of that IP is clearly documented. And oftentimes we see that held by the company or one of its subsidiaries. So sometimes founders will miss, their own IP assignment to the company. And that extends then to other service providers that you bring on, third parties you're doing business with. You know, there should be an expectation that's set early on that founders are going to assign everything they own to the company. You're going to keep out IP that they've done business with. It's not relative to the company. And all employees and contractors are going to have to sign similar provisions so that ownership is clear. And it really impacts a lot of agreements with vendors, investors, and everybody else. You want to make sure that it's clear. It's an easy thing to miss, but it's also commonly included. So we want to make sure that that's properly documented starting from the onset.
Okay. And is it too early to start that? I'm just curious. So I'm a founder and maybe I've got an idea. Derek's smiling. But is it too early, Mark? I don't know. When do I kind of pull the trigger and say, I really need to meet with an attorney?
Yeah, it really, to me, starts when you form the company. You know, oftentimes you've got to document what's being contributed to the company in exchange for the equity. And that's where I usually pinpoint is the proper place to start that assignment. When we form a company, that's usually one of the first conversations we have. Well, you're a founder. What are you contributing to the company, whether that's cash, other property? The IP is an obvious one that oftentimes gets missed. And so that oftentimes we try and document that as one of the very initial contributions to the company is everything that you have created already and that you will be creating as a founder moving forward. I think that relationship as a founder, because you're wearing so many hats, you don't think oftentimes, well, I'm also an employee, an officer, and all these other things. And so if I don't contribute that and have a continuing assignment of everything I create, then if there's a split between one of the founders and the company later on, that's a potential vulnerability that you have.
Okay, thanks. Derek, how about from your personal experience with all the startups you've done? What are some of the common mistakes?
Well, I think when we talked earlier this week, I used the word good corporate hygiene, and essentially that's what Mark and Terry have been talking about, which is, you need a, confidentiality agreement, non-disclosure agreement, all that kind of stuff, the assignment of intellectual property. Everybody signs it. It's the same form for everybody. And you put it in a folder, and, it's there, and hopefully you don't have to refer to it down the road. The other thing is when you go to raise money, investors, particularly professional investors, are going to want to see all of this documentation in their due diligence. And so if you organize it as you go, then it's all there and ready. And, I think investors will appreciate it. And if it's disorganized or incomplete, it start raising questions in the investor's mind about, how disciplined are you about executing this? Okay.
Good. And later I'll talk a little bit more about IP and investors and would love perspectives on that. And Ollie, from your perspective, some of the common mistakes.
Well, so it depends on the stage, right? Your multi-time founders, your experienced or second-time founders, they're making less of those mistakes, and the investors appreciate that, right? But as much as we read about multi-million-dollar CEOs, most entrepreneurs start with nothing and then later become those multi-million-dollar CEOs, and it's trial by fire the whole way. So the first thing you do is you get sued because you did it wrong, and then you learn from that, and the next time you do it right. You reach out to an attorney, or a simple USPTO.gov trademark search can save you tens of thousands of dollars, just on the start, right? Just on the start.
Okay.
And obviously, I'm speaking from personal experience.
Okay. No, that's very helpful. In fact, I'll stay with you, Ollie, and we'll transition to sharing an experience or two about where IP played a crucial role in your success. You may want to say failure, but in your success, and what kind of role did it play? So you say, "Wow, I got that one right," and then maybe one that you didn't get so right.
Yeah. So usually you're not getting it right first. You're getting it wrong. You're learning and adapting quickly, and that's really how you get ahead, is learning quickly. I was in the professional sports industry. Had a manufacturing company. We were importing and designing professional boxing gloves, right? And the name of the company, I won't say the name of the company, but it wasn't clear that someone would be able to trademark the root word that we used in the name. So of course we received a letter, right? And that's how we learned and adapted quickly. But now, obviously, that was my first, that was one of my first businesses. That was my first international company for sure. What I've learned over time is, and from that experience, is you just do a search, right? Even if you don't get the attorneys involved at that stage, because usually when you're really starting out, if it's really early stage startup, you don't really have $10,000 to spend on an IP attorney, right? So at that stage, what you're doing is you need to do some preliminary research. You need to find out for yourself. And it's really, really important, because ultimately, whether you have a product or a service, what you're building in your company is a brand, right? And that brand is the intellectual property.
Okay. All right. Terrific. Terrific. Any sense of, and I'm thinking of value, the value that the IP brought you, in any example you can think of. So, hey, why do I spend this time doing this? Besides protecting me in some way, is there an upside?
Well, it's that branding, right? It's that branding. Once you have developed that brand, right, that feel, which is protected by intellectual property, your designs will come and go, right? Just like in the fashion world, just like in the automotive world, your designs are going to come and go. They're going to change over time, right? And people are going to copy them if they're successful. But the most important intellectual property you own is your brand, your logo, your feel, your messaging, right? And that is going to make you money over time, because if you're successful with it, people are going to recognize it. They're going to associate it with success, right? Or they're going to associate it with quality. And that's the end of the day.
Okay. All right. Thanks. I'll shift over to Terry. Terry, examples you have of where IP was a good move, that it helped that company to follow the rules, basically deal with an attorney and get the IP right.
Well, I've got several. I mean, for the most part, they're all kind of the same.
Okay.
I think one of the key issues that I've tried to get clients to focus on is more strategically. And from that standpoint, I mean, are you just looking at being in the US, or are you looking at worldwide? Now, that may not be something, I mean, this is building your 5-year strategic plan, looking down the road. Where that comes into play too is with respects to your investors. I've had clients, we've gone US on the IP, then they're getting investors from overseas who want to bring it and want to know what IP do you have in their particular country. Fortunately for most of my clients, they have been able to pivot. They haven't missed the timeline, or they've got new technology that we could then file where we're trying to cover more than just the United States. Piggyback on what Ali said, I agree. When he says branding, I mean, from an IP's perspective, that's usually your trademarks. That is your most valuable IP. And the reason I tell clients this whenever I talk about it, patents are time limited. You get a patent, it's good from 20 years from the filing of that patent application. Trademarks go on forever. There's trademarks out there that are still registered, that have been registered since the 1800s. Key there is building up, as Ali already pointed out, the goodwill that's associated with that brand. So even as you pivot, go to different products, different services, people are going to recognize that brand and say, oh, that's a good brand. I will go try this new product or new service that they have. So definitely branding is key. Determining a brand or selecting a brand, a lot of people want to pick something that's descriptive of what their goods or services are. They shouldn't. They should pick something that's more fanciful, something that when they put their stake in the ground and say this is their brand, it'll be harder for anyone else to come in and use it as well. Even if, I mean, they may not be close, but if you had it for a number of years, you could claim that, and it is a number of years, you can possibly claim that you're now, your brand is famous. So even if someone uses it in a different arena that's not even close to yours, you could potentially stop them from using it as well.
Okay. Terrific. Thank you.
I'll
Thank
give.
you.
I just want to provide some. I
Go
want to
ahead,
provide some
Ollie.
context
Sure.
Yeah, I want to provide some context with what he just said. So
Mhm.
the company that I talked about, where we were sued for intellectual property, and we didn't actually sue. We just ended up changing the name, right? So we didn't actually go to court. But it was a professional sports industry company in professional boxing on TV, right? We were
Mhm.
sued by a skate shop in South Carolina. Okay,
Hmm.
not really related businesses, but but when it comes to intellectual property and the way that the filings are done, it is a related business.
Okay. Thank you. Thank you for sharing that. Derek, I know you have a number of good examples of.
Yeah,
Please share.
I'll continue with the sports vein. When we were with Sportsline, we had, applied for trademarks, and after we did the deal with CBS, we ended up getting sued by someone who had a radio show that was termed Sportsline. And they saw a big opportunity, and we were moving to an IPO, and there were depositions and all this stuff. And you also have all these categories of goods and services. So think about adjacent categories as well as the primary category that you're in. The long and short of it was we settled and paid them off because we wanted to do an IPO and wanted, to eliminate any noise, right? So it was a holdup, and, such is life. So I think you've got to be very thoughtful about it and look broadly at, other people using the term. Your artwork is very crucial. So you want something distinctive. I'm going to turn now to patents, because that's the other side of the coin here, if you will. Patents are expensive. So you need to figure out how to do as much of the work yourself, so that you reduce the costs and work with people who are experienced and can help you get it done. And you need a strategy, so you have to think very thoughtfully about it. One example I have is with Strands. We had this early recommendation engine technology. We had several patents around it. Our original business was music recommendations. And to be honest, commercially, we didn't make a lot of headway. We had great technology, and we ended up selling the patents, actually a license to the patents, to Apple, which was fantastic because we got a bunch of money, and then we pivoted and focused on fraud detection, and those patents that Apple wasn't going to use for other things were very valuable for us.
Terrific. All right. Thank you. So in selling those patents, you said Apple wouldn't actually use them, or they were just
They would
protecting.
use them for music related
Okay.
stuff. And we were able to carve out, essentially a lot of stuff that we could use them for. And we did successfully.
Okay. Terrific. Terrific. Mark, a different question. So when you're sitting negotiating with investors, right, you're going through term sheets, what role does IP play? How does that factor into the discussions as we're talking about maybe, and I know Ali said it is early on, I'm going for my first money, or later I'm raising series B and C. How does it play into that?
Sure. Yeah. Well, of a lot of our clients, the IP is one of the primary assets. Particularly if you're looking at something that's patent worthy, right? So that might be the core asset to the business. And then the brand, as was discussed here before, if you develop some brand recognition, that also goes a long way into what value the business has and what value the underlying service or product has. So oftentimes it's particularly interesting with a startup because it can be very difficult to put an objective value on IP or even the business at a very early stage. So, one of the questions in determining that is, do you have revenue yet? And where are you at in that life cycle? Because we've got investors that come in at a pre-revenue stage. And if you're looking to do, a Series A or something later, then there's an expectation that, you have some revenue coming in. So one of the questions is, do you have any actual income to help form a valuation? And if not, then it's, in my opinion, very speculative. So one of the things that you'd be looking at would be, what are some comparables that are out there? So depending on when you're fundraising, you want to be thinking about a couple of things. One is, obviously trying to come up with how you would go to market, whether it's raising money or just going to market with your business idea. And then two, presenting that. Derek touched on something earlier that I think is important. When you're soliciting investors, they're going to want to know about the IP because that's a key determining factor in what the value will be, and then how you're protecting that. Because if it's a mess, then you may not be investable at that stage. So, to one of Terry's earlier points, I do think it's important to sit down and map out. We've got this idea, we've got this brand, starting to map out how we want to approach that, not just from a protection standpoint, but also how to exploit that and derive value from that.
Okay, good. And I'll just continue with you for a minute. Mark, what rights do those investors have to that IP? What can they, claim to it depending on what happens with that, company? And then I'll ask Derek. I think he's got an example, but yeah. So what do they like? So I'm happy. I've gotten my $1 million check. I'm happy. But then what happens? Let's say if the company doesn't continue, you've got to declare bankruptcy or what have you. What happens to that IP?
Yeah, well, I mean, in an early stage, it really boils down to, what level of control your investors have. For most early stage startups, you're typically not selling a controlling interest in the business. There are different investors that invest with different strategies, but oftentimes, venture capital and angel investors are not taking a controlling interest. So they're more passive in that sense. You get into bankruptcy, then the equity owners, as many VCs and angels would not be first in line to collect if you've got creditors that exist beyond that. So there's not usually an expectation that an investor would wind up with ownership of the IP unless they have a controlling interest in the business. But obviously there's an expectation that the company would maintain that ownership. And then if you do run into a position where the business is going out of business or going into bankruptcy, then you've got to go through the analysis of what creditors exist and who has proper claims to the asset.
Okay, thanks. Derek, did you have an example to share with us?
Yeah, I mean, I think I'm just echoing Mark's comments. There are, as the equity holder, you're at the end of the line. So when you are a founder, you're typically the equity holder, and investors will come in with a convertible note or preferred equity of some kind, and that may have certain rights and preferences, and sometimes security, which can include your IP. So when you're doing those deals, you should be cognizant of what you're signing and, what the various provisions are. I think, I've seen cases where you've got a patent and that, you use it as security, and then when you run into trouble financially, the ownership of that patent can be at risk. So you've got to be very, very cognizant of what you're doing.
Okay. All right. Thanks. Terry, anything to add to that as far as, you're working with investors and how do you position your IP? And, obviously as a founder, you want to protect that, but, what's the interplay there?
Kind of what Derek's and Mark's kind of gone over with
Okay.
already for the most part. I mean, and again, it goes back to me all towards that whole strategic planning. So yeah, as you bring in investors, it's understanding and knowing how you're positioning the IP. I know Mark mentioned about the value of IP. I mean, there was a study, there's an organization called Ocean Toma. They do a study about every 3 to 4 years looking at the S&P 500 to say what is a company's value. Back in the 70s, that value was in the brick and mortar. Now 90% of the value of the companies on the S&P 500, it's actually the 90% of their value is in their intellectual property. Their intellectual property, and I'll even include in that intellectual property, besides what we've talked about today, their trade secrets, big data. You think about companies like Amazon, Facebook, Google, their assets are the big data that they've collected on us, companies, and then they keep it as a trade secret. So that's another aspect that we haven't touched on much or yet today is the trade secret aspect. Some companies need to look at that as well as to from the standpoint if my rule of thumb I tell clients is if it's something that can be reverse engineered, then you should look at filing a patent on. If it's something that's not able to be reverse engineered, you may want to look at keeping it as a trade secret. And then you need to make sure you put the right safeguards in place to ensure that it always stays a trade secret, because once the cat's out the bag, you cannot put it back in.
Okay, thanks. Ali, I'm gonna shift to monetizing. How do I monetize that IP? Because thank you, Terry. Exactly. There's a whole lot of intellectual property out there that may be trade secrets. But Ali, from your standpoint, how do you leverage and monetize your intellectual property?
So innovation is iterative, right? So a trade secret is just doing something that other people are already doing, but doing it in a different way that's probably more efficient or more profitable, right? So quite literally, just the course of doing business is how you monetize them. And then if there are other opportunities to monetize, for example, you have a patent on an algorithm or a technology like Derek spoke about earlier, you just license that out and you get paid royalties, right? You can license that out to a big player who has more distribution than you have. And this kind of actually taps on both what Derek and Mark said earlier, right? Where with like equity holders being last in line, that's because capital and distribution are all of the leverage, right? And they're not just the leverage when it comes to what the equity holders own, they're also the leverage when it comes to what the intellectual property is going to be worth. They're the leverage when it comes to the licensing and the royalties, right? Apple, for example, had enormous distribution, which is what made that patent enormously valuable to Derek, right? And if you're learning about this stuff in Mark's office and you're already deep into your business, it's going to be an expensive lesson. you need to call him. You need to call him first.
Let me just give you an example. I was in a situation. Somehow I ended up as an investor in a food technology company that was going to have their own brand. I mean, they were building their own brand, but they had this technology that they were going to use to revolutionize, a bunch of stuff. And it was in the pet food area. And they just didn't have the scale or the ability to do their own product, which was their dream. And finally, we were looking at the situation and I'm like, why don't you go to the people who are already in the pet food business and license this technology? Because you're hitting your head against, and they ended up doing a license deal, which, I mean, it was like owning an oil well. It was fantastic. And they kept trying to do their own brand, and eventually they decided it's not worth it. but the investment ended up being reasonably good because they did the license deal. And as Ali pointed out, these people had the distribution and the shelf space and the sales force and all this stuff that you have to do to run a business. And it was much simpler to just do a license.
Yeah. Okay. So definitely
Well,
what I'm hearing is get on top of your IP, be smart. Terry's saying be strategic, because there may be value there that you don't even know, down the line, right? To Derek's point is it may be something where I just license it, I'm not going to build it, but I'll license it out
And
there.
let me make when I was in the HTML social mobile gaming business, it was one of those.
They made those with HTML.
Yeah, I mean, we were the first social mobile gaming company to use HTML5. Sorry, and that was a revolution, and it was with the iPhone, and it was fantastic. And part of the issue was we were really, our IP was very often a feature, not the core. And
Yep.
and the other players in the industry, which were Zynga and Playdom, which became part of Disney, they could just do so much more with their organizations against our pipsqueak outfit that, it was better for us to license stuff to them.
Mm-hmm. Yeah. Perfect.
I think it's
Go ahead, Ollie.
I think it's a really common misconception with early stage founders, right? Seasoned guys like Derek already understand this, right? The value, the things that you need, the formula that you need to create value in a marketplace, right? There's only two things: the efficiency, which is the intellectual property, right? And the distribution. Those two things are all that you need to make money in a marketplace. Capital is just something that you use to get one of those two things, because you usually have one and need the other, right? And I think the most seasoned guys are guys that are out there, guys and girls, are the guys and girls that are out there looking for efficiency, intellectual property plays, and looking for distribution that are both in their network and just putting the two together. And in that case, most of the time, you can actually do it with little to no capital as well. And I think that exemplifies the power of intellectual property.
Yep. Yeah. No, I agree, and that's why really one of the reasons we're doing this, because people go, "Oh, intellectual property, is that as exciting as talking about how do I sell better, right, and go to market?" But I think you're right. And Terry's mentioned it too. This is the value. This is the asset. How do I protect it? Because it takes many forms, right? I can translate it into a good revenue stream. So terrific, Terry. And I know we've talked a little bit about artificial intelligence, and in that space, how do I protect my IP if I start to say, "Hey, I've bolted on AI," or maybe that's the foundation of my platform?
Before I touch on that, let me touch on the monetization a little more. So,
okay.
From the monetization perspective, in most cases, you see the companies going out trying to find the licensing. One of the services we've added this year is we are able now to go out and find potential, I would use no other better term, targets who might already be close to using your IP. In this case, I'm talking patents, and you can then target maybe a little broad, cast a wider net on people who might be interested in getting a license in your patent. Or you may realize that they're actually infringing. So you might want to take further steps to make sure that they're not competing against you. There's, like I said, we've got tools now that we actually provide that as a subscription service to our clients. The benefit is, from a client perspective, they can keep focused on what they're working on and not worry about seeing who's out there until they're ready. The other benefit is we talk patents, less than 5% of all patents that ever have issued have actually gone to market. So there's companies out there with patents that really, yes, they hold on to them. It adds value to their company. But they're able to possibly monetize it by getting licenses. But because they're just holding it as value, they're not looking beyond that value in the company. So again, the tools that we have now, you could actually use it to do, like Ali said, like Derek's talked about, licensing to other players that could be, again, adding a new revenue stream. The other benefit I see with it is with patents, you've got to pay maintenance fees. Most of my clients will pay the 3.5-year maintenance fee, but then there's a 7.5 year, then there's 11.5 year. Each time that fee escalates. And a lot of my clients are like, why am I paying this? We're not using the IP. They don't see where it's really bringing value to their company.
Got it.
Using this monitoring process, it's again an opportunity to say, okay, I paid the 3, maybe at the 5-year point, I start trying to actively look at a license so I can get value out of it.
Okay.
Now,
Terry, I'm starting to worry that you're that guy who sent me all those mean letters.
He might be.
It might be, but under this approach, we're trying to send nice letters. We're just trying to say, hey, here's an opportunity. Your other question?
About artificial intelligence.
right.
How has that kind of introduced, what am I doing with this IP? Do I really have it? Is it being shared with the world? Yep.
The biggest issue with artificial intelligence right now is if AI is creating, because AI can create. Google has used it to create, I forgot, it was like 8,000 different materials. The further issue is you cannot get a patent if AI creates it. The significant input has to be human. So there's guidelines that the United States Patent and Trademark Office has put out to try to help you understand when you can and when you cannot. Same issue has come up with copyrights because you've got music, you've got artwork. If AI is doing the creation, there's no copyright that can be had. There's been situations where people have written books and they've used AI to create the images. They've gone to get their book copyright, or get a copyright on their book. There's situations where the copyright has been issued. Then when it becomes known that, hey, the images were created by AI, the Copyright Office has gone back, adjusted that copyright to say, you've got the copyright on the text, but you don't have it on the images. So AI can be used as a tool to help you, I guess I would say, enhance your invention. But as long as the underlying invention is still man-made or woman-made, human-made, you can still get a patent on it.
Wow. Mark, have you worked
that's
with...
still up in the air, too.
Sorry, what's your question,
That's
Bob?
still up in the air from a legal...
I was just asking Mark, any experience with AI and your clients? And what does that mean from an intellectual property standpoint?
Yeah, we do. We work with some AI companies. The software itself is going to be protected similar to other software, but to Terry's point, the creation of that does render a problem. There's a famous case where they had a chimpanzee take a photo, and the question was raised, well, can that photo be copyrighted? Like anyone else that takes a photo typically owns that copyright, but it boils down to what wasn't created by human, and that's inherent to being able to create intellectual property under the law. So that's the problem, and like was mentioned, it's still developing. The law tends to lag behind technology, so I'm sure we're going to see some changes in that moving forward. But there is some value in the way that the data is put together, processed, and used when it's been processed through various software, whether it's AI or otherwise. So it was touched on earlier, but I think a lot of companies don't even realize that there are ways to exploit some of the data that they're gathering, and we've seen a tremendous amount of uptick in people realizing the value in that. So it's impacted not only the way you look at everything else that you're creating and processing. But as you go to negotiate with vendors, developers, and everyone else who's got a hand in what you're creating, one of the negotiating points is, well, we're creating a lot of data. Who's going to own it? Who's going to have rights to use it? And that can be heavily negotiated because people are starting to get hip to the idea that there are ways to take this data, aggregate it, anonymize it, and still use it in a way that has a lot of value to it. So I think you're going to continue to see that, and we'll see how things shift with the way AI is viewed. But, you know, for now, anything that gets created by AI is going to have that inherent problem that it's not created by a human. So, but everything we were talking about made me think of something earlier. What struck me is that, you know, we do have a lot of opportunities in marketplaces now that exist that didn't before. When you just have an idea and you're not sure, I don't know if I want to be a founder, but I've got this great concept and I know no one else is doing it. And once you get to that stage, how do you monetize that? Do you guys remember the old 1-800 number that used to come on late night TV? Says, do you have an idea? We can patent it and monetize it for you. Luckily, that's not your only option anymore. And even if you're at a stage where, say, you're a developer, you don't want to build a business, but you can build a tool or you can build a simple product or a concept. You know, there's marketplaces now to go sell that at its infancy, at just the concept stage that didn't exist in the past. So there is some opportunities now for folks that don't want to build a full business because, you know, the points made earlier, distribution, marketing, these are, you know, manufacturing, these are all head cost areas that you're going to have to raise capital for, and you're going to have to build, and you're not really doing maybe what you love at that point. You're not developing and creating. So luckily now there are new marketplaces. You know, I can name one off the top of my head, acquire.com, for example, if you just want to build a concept and go sell it. And there's other traditional there's ways now to take a concept and sell it. Or you can go the more traditional route and say, look, I'll license this to a bigger corporation that's already got all those channels in place. But luckily now the market's a lot friendlier to folks that makes the decision tree, you know, more options available.
Sure. And thank you for sharing that. Many of the founders we work with, you know, kind of go through the early startup phases and they kind of go, wait a minute, I don't want to run a company. I've just realized that's something I don't want to do, but what are my options? So thank you for sharing that.
It's not just creators and founders too. You know, we've seen multinational corporations have a lot of IP just sitting around, they're not using it. And so they'll either look to internal folks who have helped develop it to split off and create something new that they can partner with. Or, you know, we've seen outside parties come in and say, hey, look, we know you've developed this. We've already got stuff that we can build around this to help support it. So even on the flip side of that, multinational corps might license out to smaller companies to help develop an idea they're not using.
All right. Fantastic. Derek?
Yeah, I mean, where to begin? So one of the things that we do at Edisource, because we're dealing with publishers, and ultimately they're dealing with advertisers and their audiences, you know, we have an audit trail on every piece of content that we produce for our clients, and it's in our, you know, platform. So you know what the source material was, because there may be copyright issues. So you want to know, is it, you know, source material that there's, you know, I have the copyright and can do whatever I want with it. No one can come after me. Everything that's produced, it will tell you where it came from, what was created from AI, what was created from the source material, so that you know exactly who owns what and where it came from. The other thing is that we essentially operate a clean room. So, you know, the worry with AI, especially if you're a publisher, is that they suck all the intellectual capital out and reuse it down the road. So our, you know, with the prompts, et cetera, it's in a clean room. So you retain that and it's yours and it isn't going back somewhere. And we think that is going to be important as well.
Okay, terrific. Ali, did you have a comment?
Yeah, I was reading the chat and I saw someone posted a
please.
question about software, protecting intellectual property within software. Now, I'm not an attorney. There are two really qualified IP attorneys on this call who can answer the protection side from a legal perspective, definitely way better than I could. But what I can tell you is that efficiency that we were talking about earlier, that is your IP, and the distribution being the two most valuable things, go to market, right? You go to market, you scale, and that's going to give you the most protection, is actually just eating market share, right? At least from a business perspective. And then I'll let one of the attorneys take it from the legal side on that one.
Yeah, the question was, software has many patent limitations. How do companies protect software when they fail to meet the novel utility component? Either Mark or Terry, you want to
Go
take
ahead,
a
Mark.
swat at that?
Yeah, well, software is tricky when it comes to patents, but copyright is one thing that's available. And part of that process too is making sure that what you have remains copyrightable. So we're looking at, do you have open source involved, or other folks are, integrating open source. So you got to be careful with that. But honestly, I agree with Ali. I mean, a lot of the things that we're talking about with clients early on is, you can derive ownership and IP just by creating it and publishing it. So in an ideal world, the first thing you do is sit down with Terry and say, hey, look, here's all our ideas, and we start protecting them and then go to market. But if you're looking at something where you want to grow at a rapid pace to be attractive to certain investors that are really looking at that rapid growth model, you may have to start publishing and going to market before you're in a position to have everything perfectly registered. So probably not the best thing for an attorney to tell you, but there is some business sense in that, right? So I do think early on, particularly at the proof of concept stage, you want to sit down with an IP attorney to go over, is this something that's patentable? From a cost perspective, does it make sense to put a patent on software? Because there are some limitations to that. It may have diminishing returns. I think copyrights are pretty easy and inexpensive to get. So that would probably be, an easier route to get some protection on that. And the life of a copyright is much longer than that of a patent. But generally, there's some other practical ways to protect your code beyond just the IP registrations. Keeping that, tight. We always try to avoid things like IP escrow and things like that when folks have to get involved. You can't always do that, but there's some also practical ways to keep folks out of your code. So, to Ali's point, I think getting into the market and creating a business around that creates value beyond just, the IP itself. So, I think when it comes to software, you do have a decision to make as to how to allocate resources if you're a startup, on which registration to seek. But you can start publishing and you can start deriving copyrights under the common law. There's some clear advantages, obviously, to filing the registration, and there's some clear advantages if you can patent that. To Terry's earlier point, you've got a real limited time to do that. So all things that, like all founders, you've got a million different things running through your head at once, but there is certainly some advantage to getting out and being first to market. It's funny, I took a patent class in law school, and the whole book that we read in our patent class was how patents are really only appropriate for certain industries. And really, if you can get out to market and get out ahead of it, sometimes the amount of time and the limited duration you have to protect the patent isn't as valuable as getting out there first, particularly with something that can be reverse engineered. So it's all something that has to be weighed. But generally, if you're following the best practice, you'll start with freedom to operate analysis to make sure you're not infringing. And then what are my options? Is this a piece of software that has utility that we can actually have a valuable patent for? What are our copyright options? What are our trade secret options? And deciding from there, how quickly can we get to market, and how much of how much heartburn are we going to have trying to be as tight as we can on IP protection?
Sure. Okay, and thank you for sharing that, because working with so many early startup founders, it's like, I want to just get out there. I want to get to market, and often they see this as kind of, okay, you're kind of holding me back. But part of the reason we're doing this is, hey, there's a whole lot of value in here, so take take some steps, get the conversation started, at least scope out what the options are with the attorneys. We think that's a good approach. One question came up, Terry, maybe you can quickly answer this. We're getting close to time. People are saying budgeting. What do I budget? What's the cost to, and I'm thinking, what's that initial consultation and then moving forward? Because obviously startups have very little money. It's like, what am I getting myself into here? So.
Well, that budget can vary. I mean, for that initial consultation, it depends on how the attorney handles it. I typically do like a 15-minute to 20 to about 30-minute discovery discussion with them, where I don't charge. It's just, let's sit down, let's see if this makes sense, what you're looking at doing. And at that point, I or at least outline, hey, this trademarks make sense, patent makes sense, copyright. We'll at least have that initial discussion. But typically, I mean, attorney fees these days, it depends on the attorney, can run anywhere from, I'd say, probably about $300 up to, I think in Orlando, some people are charging close to $1,000 an hour for that. And that's just the hourly rate. I mean, a lot of things we do on a flat fee basis. So with respects to filing a trademark application, it's on a flat fee basis. Our patent applications, once we understand the invention, we also basically quote a flat fee. The reason we do that, we don't want the client to feel like, oh, how do we know he turns the meter on? How do we know all that time? I mean, you want something so you can, as you already said, budget. So that's how we set up a lot of our fee process on patents and trademarks. Even if there's something new that comes up, we will quote it up front so that the client knows what the expectations are.
Okay. All right. Terrific. Thanks. Any last quick comments? We got like 2.5 minutes left. Anybody want to add anything finally? Maybe some advice for startup founders?
I'll throw something out there.
Go ahead, Terry.
Oh, essentially, I would recommend trying to talk to a IP attorney early on, just to get some general information. It may not even be who you decide to use moving forward, just at least get someone else's perspective. And I even say that because there are some investors who would rather say, look, skip the IP, let's go straight to market. As a founder, I think you owe it to yourself to at least hear the full perspective and then make your decision.
Okay. All right. Ali, final word.
I was going to say exactly that. I was going to say that I mean, the resources are out there. You can educate yourself. I see, questions and a lot of questions in the comments about like protecting code and go to market, but go to market with an educated idea as to how to protect yourself if what you're doing works. If what you're doing doesn't work, there's a lot of risk in front loading the money, right? So talk to somebody like Terry, especially like, I never heard that before. A free consultation from an attorney on something as valuable as intellectual property is great, right? If he's willing to sit down with you and give you advice for free, take that advice, take that education, read online, and then go to market with those protections in mind.
Okay. All right. I'm going to wrap up. Thanks again to the 4 panelists. I really appreciate your time. And Ali, I know this is early for you, so thanks for getting up early. Really appreciate all the time. And we'll be back for the people online watching. We'll be back on March 11 with another 10X talk. So thanks, everybody. Appreciate it. Have a good day. Take care.
All right.
Thanks, everyone.
Thanks.
Thank you.
Bye.